Everyone, I'm here to introduce our next speaker, Professor Sandra Simkins. Professor Simkins created and co-directs the Rutgers Children's Justice Clinic, the first clinic at the law school to focus on children. She is a national trainer on the issues of girls in the juvenile justice system and is involved in conditions of confinement reform. Prior to joining the Rutgers faculty in 2006, she spent 15 years working in criminal and juvenile defense. She served as Assistant Chief of the Juvenile Unit at the Defender Association of Philadelphia, supervising and training a staff of 40, including 23 lawyers, to represent children in the juvenile justice system. Professor Simkins also was involved in a wide range of national and statewide policy reform for children. In 2009, Professor Simkins was selected as Lawyering Professor of the Year, and in 2007 she received the New Professor of the Year award, both at the Rutgers School of Law, Camden. In 2008, she was selected by the MacArthur Foundation to participate in the Models for Change Juvenile Indigent Defense Action Network. Since creating the Children's Justice Clinic, Professor Simkins has been appointed to several New Jersey committees, including the Supreme Court Committee on Women in the Courts, the Camden Safer Cities Initiative, and Camden County's Steering Committee for the Annie E. Casey Foundation's Juvenile Detention Alternative Initiative. Professor Simkins also co-directs the Northeast Region Juvenile Defender Center, a subsidiary of the National Juvenile Defender Center, where she provides consultation and training to child advocates in Delaware, New Jersey, New York, and Pennsylvania. She has championed the creation of effective statewide coalitions and led fundraising initiatives for program development. Her various fundraising efforts have created a specialized mental health and special education attorney and a statewide training program for juvenile defenders in the state of Pennsylvania. She was selected by the Harvard Business School Social Enterprise Philadelphia Club in 2005 to participate in advanced nonprofit management training. In 2004, she was chosen by the MacArthur Foundation to partner with the Foundation's Juvenile Justice Aftercare Initiative in Pennsylvania and was being recognized in the Philadelphia Lawyer for providing strong advocacy for children at each stage of juvenile court involvement. In 2002, she was the recipient of the American Bar Association's Award for Outstanding Representation of Children. Professor Simkins has taught the Criminal Defense Clinic at the University of Pennsylvania Law School and Juvenile Law at the Temple University Beasley School of Law. Please join us in welcoming Professor Simkins.
Thank you so much, Kendall. Kendall picked me up from the airport. It was so nice. So good morning. I'm Sandra Simkins, and I'm the Due Process Monitor. I have to say I'm really happy to be here. This is about my 4th or 5th time being in Memphis, and it's starting to feel like home. Things are much better for me now that I've learned how to manage my own coffee addiction. During my first compliance tour, I nearly died because what I learned is that downtown, you guys only have one Starbucks, and it's out by the FedEx Forum, which is nowhere near juvenile court on Adams Avenue. And I was really struggling. Fortunately, I discovered these little packets of instant Starbucks, so I'm good now. But I think if my career as a defense attorney doesn't work out, I'm going to open a franchise, over by juvenile court. Hang on, let me get my... Can I have the IT person help with the...
I apologize for just a minute here while we get this back loaded on here.
I'll grab some more coffee. Almost brought you. Get out here.
Oh, it's right here.
Yeah. There we go.
Yeah.
There we go.
Good, thank you.
Thank you.
I always have one of my teenage kids help me out with all the tech stuff. Anyway, so I'm a law professor, so I get to ask hypothetical questions. And so what I want to do is I want to have you imagine with me that you and your daughter or niece or granddaughter are taking a trip from Memphis to Orlando to go see Cinderella's castle at Disney World, okay? And I want you to imagine that along the way you stop at a rest area outside of Tallahassee to get some gas. And as your daughter goes into the ladies' room, there's some water on the ground, and she slips and breaks her arm. How many of you would feel comfortable using the doctor at the local Tallahassee hospital to treat the broken arm? I would. Most of you, right? Most of you. I want you to imagine this same trip to Disney World, but this time, when you're parked at the rest area outside of Tallahassee, a police officer walks by your parked car. He looks in the back seat and he sees what he believes is a bag of drugs hanging out of your daughter's purse. He searches the purse and finds a large quantity of cocaine and about $900. Now, your daughter insists it's not hers. She's holding it for the boyfriend, the one that you hate, right? But nonetheless, she's arrested, and because she's 17, she's facing transfer to adult court. How many of you are going to be comfortable with the local public defender or court-appointed counsel to represent your niece or daughter or granddaughter? One. Good. I wouldn't. No way. And the reason I wouldn't is because I would have to do a whole lot of my own independent research. Because unlike every doctor in the country, when it comes to juvenile indigent defense, it is quite simply justice by geography. When you're a doctor, you get training, supervision, and you go through a residency. But when you're a juvenile defender, that frequently doesn't happen. If you get lucky and your child is arrested in a jurisdiction that has well-funded, well-trained juvenile defense, then your child has a good chance of getting a fair shake. But if you don't, then you have to trust in the power of prayer. The reality is that across the country there's a crisis in indigent defense, particularly juvenile indigent defense, and many public defenders simply don't have the resources to adequately represent children. And this is a big deal. It's a big deal because what happens in juvenile court can have lifelong collateral consequences. One of the biggest myths in this country is that people think it just goes away. People think that whatever happens in juvenile court just goes away when you become 18, and that is simply not true. What is true is that juvenile court has become much more punitive over the last 25 years. And so what happens in juvenile court can have impact and prevent enlistment in the military, access to public housing, impact mortgages, the ability to get certain professional licenses, and sometimes can result in lifetime sex offender registration. As most of you know, when the Shelby juvenile court investigation first came out in April of 2012, there were many problems identified. And Winsome went through some of the problems that were identified. And yet, while the report made national news, for those of us in the field, it was an old, familiar story. The problems identified in Shelby are problems that we see across the country. And I know this because I've been in assessments in states and in courtrooms in Ohio and Illinois and Pennsylvania. And in some of these courtrooms, it's common practice for the probation officer to sit at the bench with the judge and tell the judge what to do on the child's case. I've been in courtrooms where the court has instructed defenders not to file motions or doesn't let the defenders have discovery. I've been in courtrooms where defenders don't even keep files. After every court hearing, all the court papers just end up in the trash. And I've been in courtrooms where nobody can remember the last time a witness has been called. And so the reason what's going on in Shelby is so historic and so important is because it doesn't just matter to Memphis. It literally matters to the rest of the country. And I really believe that when Shelby is successful, it will be a model for other jurisdictions to follow. So what I want to do is I want to talk about two things. One, why what's going on in Shelby matters to the rest of the country, but then I also want to talk about why I think the agreement signed between the Juvenile Court of Shelby and the Department of Justice provides a roadmap and the components of success that I think others will be able to follow. So let me start with how we know. How do we know that the problems here are like problems everywhere else? And it starts back in 1995. In 1995, there was a national report entitled A Call to Justice. And A Call to Justice basically said, in looking at juvenile courts around the country, it's not good. It's not good. And kids aren't being represented well. The thing about A Call to Justice, though, is that it was a broad national report, and it wasn't individualized enough. And so what the National Juvenile Defender did next is they started to do individual state assessments. Each state assessment was supported by the American Bar Association and the local leaders on the ground. And at this point in time, there have been assessments done in 22 states: Montana, Mississippi, Missouri, Ohio, Pennsylvania, North Carolina, South Carolina, Georgia, Illinois, Colorado, Indiana, Texas, Louisiana, Maine, Kentucky, Nebraska, Virginia, Washington, and West Virginia. And even though each one of these states is really different and in different parts of the country, it's astonishing but true that the problems in juvenile court are all the same. So what I want to do next is talk about the 10 most common problems that are facing juvenile courts across the country. And it starts with timing and appointment of counsel. When a kid gets that lawyer appointed can make all the difference. But unfortunately, in many jurisdictions, kids aren't appointed lawyers until the process is really far down the line. Frequently, kids don't have lawyers at that critical point when the detention decision has been made. And research says that those couple of days in detention can be incredibly disruptive. And in fact, research indicates that time spent in detention results in lifelong negative consequences to that child, so it's extremely important. The other common theme across the country is waiver of counsel. Thousands of youth across the country waive their right to counsel. Some of you may have heard about the Kids for Cash scandal out in Luzerne, Pennsylvania. Unfortunately, it doesn't just happen there. It happens in many places. The third big problem is an overwhelming majority of plea bargains. The vast majority of cases are resolved, often at the initial hearing, often after the kid just meets that lawyer for 5 minutes, often without investigation or time to evaluate the case. Making things more complicated is that judicial colloquies are often inadequate, and so kids really don't get what they're admitting to, and neither do the parents. They really don't understand how this can impact them down the road. Fourth, there's inadequate resources. And when I'm talking about inadequate resources, I'm saying that a lot of lawyers don't even have the bare minimums, like computers or file cabinets, or access to online research, let alone paralegals, investigators, social workers, or experts. Caseloads continue to be a huge problem. Some defenders report caseloads as high as 500 to 1,000 cases, and this high number impacts every facet of defense. I pulled this slide from the 2002 State Assessment of Pennsylvania. Now, I worked in Philly, but I live in Montgomery County. It's literally a street apart. You cross the street and you're in one county to the other. Now, the thing about Pennsylvania is that there is no statewide funding for indigent defense, zero. And so there's 67 counties, and each county has its own individual juvenile justice system. And each county can decide whether or not they want to invest in indigent defense or not. Philadelphia does invest. And even though those caseloads are still very high, at least there were social workers, investigators, administrative staff, supervision, and some training. Unlike Montgomery County, where there was just 2 lawyers with caseloads of 1,100. Okay? It is much, much, much better for that kid to get arrested in Philly as opposed to Montgomery County. And this is a great example of what I'm talking about when I say justice by geography. The next big issue is inadequate training and supervision. Many youth who can't afford to hire an attorney are appointed contract attorneys, and many of these solo practitioners are disconnected from trends and developments in juvenile law. Even in many public defenders' offices, they lack specialized training. I want to give a shout out to Stephen Bush, who you're going to hear from next. He has already begun the process of this specialized training for his new juvenile unit and for the rest of the juvenile defense bar in Shelby. There is inadequate oversight and monitoring. Many systems are extremely varied and ad hoc, and states do not have juvenile-specific practice standards or guidelines. Then there's the juvenile court culture that Winston talked about, this kiddie court culture, where defense attorneys are viewed as irrelevant and unnecessary. Many other states allow juvenile court to be used as a training ground, and so new lawyers get trained. Oh, just figure it out in juvenile court, okay? Guess you'll figure it out in juvenile court. And they have to do that for a while before they get to adult court, literally gaining their practice experience at the expense of poor children. Then there's parity issues. Within some offices, juvenile defenders are paid less than the adult defender counterparts. And that's just one piece. We all know about the parity issues between prosecutors and defense staff. So the reforms in Memphis really matter. Like I said, these problems exist everywhere, and I have great faith that the strides that are made here will have a national impact. The next thing I want to talk about is the structure of the agreement. And before I go there, I just want to take a moment and really commend the incredible amount of work that has occurred here. I see some of the people in the audience, and I want to give a shout out to Bill Powell and also to Tom Coupe and Stephen Bush. I can't even begin to describe what a huge deal this is. Juvenile justice systems are really complex organisms, and so to take on something of this size is really incredible. I'm just the monitor. I'm just telling them what to do, okay, sometimes, or working with them. They actually have to do it. And it is really impressive to watch. So what Winston alluded to is this is the first time the Department of Justice has focused on an entire system. This is the first time. That's why it's so historic. From petition to disposition, that is the breadth of this agreement. There are so many players and different agencies that connect to kids, and it's an adversarial system. So this focus is really broad. The focus is asking questions as varied as what's going on in the detention centers? How quickly are kids getting hearings? Who has access to the kids' social file? Are there barriers to that access? Do the judges have information before the transfer hearings? Do they have enough time? The thing is, though, every single time you ask one of those questions, it impacts a lot of other things. For example, each new policy and each compliance measure can require a new protocol, retraining, conversation. You get the picture. In my due process section alone, so far, Shelby has been measured on 47 different compliance measures. 47. And that's just my section. There are 3 sections, okay? Overall, in the course of the agreement, there are 80 different compliance measures that have to be addressed. So it's a huge undertaking. This is just one section of the, this is one part of one section of the compliance measures that the court is struggling to address. So I want to talk about the components of Shelby's roadmap for success. Okay? There are 3 components that I think are really critical. And from my perspective, by the second compliance period, Shelby has made really terrific strides. One of the things that occurred is that there have been immediate changes in courtroom practices. Even before the agreement was signed, the court was committed to begin to make changes. And I've observed changes in notice of charges, the treatment of witnesses, self-incrimination and colloquies. What's really cool is that I believe the commitment of the court to the agreement has extended even beyond the agreement. So recently, in my first compliance tour, I was talking about the issue of transfer hearings and that the judges didn't have enough information to make a careful inquiry. The judges heard that and developed their own response and solution. They used their creativity and they decided to use their subpoena power to demand child serving agencies submit their reports to the court prior to the transfer hearing. This is awesome. This is awesome. All of a sudden, just by using the subpoena power, the judges now have access to information from where the child has been in the past. And they can decide whether or not the child is amenable to treatment in the juvenile justice system. The second big component to Shelby's success, from my point of view, is the ongoing commitment to monitoring and data and creating a data collection system. Annie E. Casey and the JDAI initiative has really taught us the importance of data and that decisions need to be based on data. I'm beginning to think that if we can't count it, it doesn't exist. You know, everything is being counted now, it seems. Every stakeholder is now engaged in some type of data collection to evaluate whether or not the change is occurring. And it's so critical that this happens because the DOJ is going to leave. And without a data collection and monitoring system that the court can use to evaluate later on, there's no way to institutionalize these changes. And that's what we want. We don't want a short-term fix. We want a long-term fix for the benefit of our children. And the data and the monitoring and the evaluation of that data is just critical. The third big component, I think, of Shelby's success is going to be the creation of a strong juvenile defense bar. Stephen Bush has already been acknowledged, but I want to do it again because when he got this project, he went around the country to learn about national best practice standards. He talked to people who are in the field doing it well, and he has brought this back. He has a bold vision. You know, he is just getting started, but his vision is vast and bold and is extremely exciting. I think that he could create a model for the rest of the country. And defenders do have a critical role. They are the check on the state's power. They ensure fairness and justice. We saw an example of this last December in Shelby, where a courageous panel attorney did an investigation and was able to get murder charges dismissed from her client. That is really cool. That is justice working. A defender going out, doing the research, and being persuasive with the investigation results she found. So I believe that what's happening here is historic because it's the first time that an entire system has been engaged. And what's so exciting is that the significant progress that's been made can really tell the rest of the country that these problems are not intractable or unsolvable. And I think that's what happens with juvenile justice. It all seems so big and so problematic that why bother trying to fix it? But that's not what's happening here. The commitment and progress that's been made so far shows that these issues can be addressed. Shelby is at the center of a very exciting time. Winsome talked about the recent Supreme Court developments and this quartet of cases with Simmons, Graham, JDB, and Miller versus Alabama. The use of adolescent development research and brain imaging techniques is really exciting. So repeatedly, the Supreme Court is saying kids are different. They're not short adults. Kids are different. Their brains are not fully developed. I remind myself of this in my own house all the time. She's 15. She's not thinking. She's 15. She'll grow up. Anyway, but the Supreme Court is saying kids are different, their brains are not mature, and so therefore they're less culpable. Hopefully this understanding about the teen brain will help us reframe the conversation about how to respond to youth offenders. In addition to the research from the Supreme Court, there are many other exciting things going on in juvenile justice. So there's the DOJ involvement here in Shelby and St. Louis and Meridian. Plus, there's the Office of Juvenile Justice and Delinquency Prevention focusing on trauma and trauma-informed care. And that's really cool, because as we begin to look at the impact of early childhood trauma and focusing on making sure our programs and facilities don't further traumatize kids, we will all get better outcomes. In addition to that, there are the recently released National Juvenile Defense Standards from NJDC, which articulates the role and responsibility of juvenile defenders for the first time. And then the extraordinary ongoing success of Annie E. Casey. And Memphis is part of JDAI and has significantly reduced the numbers of kids in detention. I was in the elevator with a sheriff yesterday, and we were talking about the numbers. And I said, so how many kids are in detention right now? And he said 35. And then he said, you know, that's down from 4 years ago when we had 95. That's huge. That is really huge progress. So I've talked about a lot of things. But at the end of the day, it's really just one standard, right? And the one standard that is really my driving focus is it good enough for my kid, right? Is the representation that's going on in Memphis or Camden, New Jersey, where I work, is it good enough for one of my own daughters? And in order for a juvenile justice system to be good enough for my kid or your kid, is that each of us has to take ownership for our part. We can't just do our little piece in a silo. Okay? And unfortunately, I think that that's what happens in a lot of justice systems. Well, I do this piece, and I just do this piece. What we need to be doing is taking personal ownership like we do in our own houses and asking questions like, does it work? Can we do better? How can we improve this? Is this system actually helping kids? When you think about it, judges have an incredible amount of power. Think about it. I mean, this judge steps in through parents' parity and says, I'm taking over as parent, right? I'm taking over as parent through parents' parity. And if the court is going to do that, we need to make sure that we do everything in our power to make sure the system helps kids or at least doesn't make things worse, right? Now, I don't leave the microphone without taking a minute to talk about my personal passion, which is post-disposition representation. So far, we've talked a lot about what goes on in the courthouse, but from where I sit, I think some of the most important things happen when the kid leaves the courthouse and goes to one of those facilities. And what I want each of us to ask is the facility actually helping the kid, or do conditions make them worse? I have a plea to everybody in this room to try to find out. For example, I know that many Memphis kids go to a place called Wilder, and you may or may not know this, but last summer the Department of Justice issued a report that said Wilder has one of the highest rates of sexual abuse in the country. That's a problem. That's a problem. We need to make sure that when we're sending our kids to Wilder, that they are not further abused and traumatized. And I'm hoping that the stakeholders in this room will do what they can to address this travesty. When I was a public defender in Philadelphia, I had the great fortune to work for Bob Listenby. And at one point in working for him, we learned that our clients were being abused in a particular facility in Pennsylvania, where we sent our kids. And I decided to file a motion. I had never filed a motion like this before, but I made up a name for it, and I filed a motion. And the motion asked the judge to remove all the Philly kids who had been sent there. There was 28 of them. The prosecutor loved this motion, just loved it. I said, this place is bad, the kids are being abused, and I want you to remove all of them. And on the day of the hearing, I got really scared because I had never done this before. And the court had never seen anything like this before. I was worried because what if I went down in flames, right? What if the judge didn't believe these kids and thought that they were just making it up to get out, right? And if the judge didn't believe these kids and then he sent them back to that facility, they were really going to get hurt, right? So I expressed my concern to Bob, and I said, I'm really scared, Bob. This could get ugly. And he said, Sandra, do you believe what these kids said was true? And I said, yes, I do. And he said, well, if you believe in these kids, just walk out on faith. Just walk out on faith. And that day, I did walk out on faith. And all 28 kids were removed from the facility. And the judge said, no Philadelphia kids are going to go to this place until the facility can assure us that all the issues are addressed. And it was really cool, because it not only sent a message to that facility, but there was a ripple effect across the entire state, and all facilities knew. And Philly has more kids than anybody else. We're one of the big counties, right? And so if we're not sending our kids to your place, you're not getting money. It had a ripple effect throughout the entire state. So, like that day in court when I was dealing with that motion, what is happening in Shelby has never been done before. And days it feels really, really overwhelming. We don't know how it's all going to work out. We just don't know. We've made a lot of progress, but we're not done. We still have a long way to go. But what I do know is that what we're doing here is really, really important. It's important to the kids in Memphis, and it's important to the kids across the country. And so I ask you to stay committed, to be patient, and let's see where we are in 5 years. I think it's going to be someplace great. Thank you very much.